We certainly have seen milk alternatives become more and more popular, but the question is charging extra for them actually discriminatory?
Our 9 News legal analyst Whitney Traylor is here to answer some questions we have. This is about a case where somebody goes to Dunkin Donuts and orders a coffee, but they're lactose intolerant, right?
Yes.
And then is that become a disability if they don't get what they need?
Or have to pay for it.
Or have to pay extra.
Pay extra, yeah. That's the idea, that they have to pay up to $2 more for either, I guess, almond milk or
something
oat milk.
like that.
Yeah. And so that's the question. I think you hit the question on the head, which is this a disability, lactose intolerance? And so under the Americans with Disabilities Act, it actually lists disabilities, a number of different things, but the analysis, it doesn't list every possible disability. So the analysis is, do you have a physical or mental impairment that substantially limits a major life activity? So the way you analyze that is you say, well, if I can't digest milk, is that affecting a major life activity? And there's an argument that yes, it is, and therefore it's a disability, and they have to make a reasonable modification.
So is this about the ADA, about the Americans with Disabilities Act, or because we use the term discriminatory, which doesn't necessarily mean, someone with a disability. This just means you are put into a different category than others.
Yeah, this is under the Americans with Disabilities Act, and that's really the question. They have to make, when you're a public entity, you have to make a reasonable modification for those who have a disability. And so that's why I think the first question made a lot of sense. Is this even a disability? And that will be part of the argument. And the same plaintiff's lawyers on this case had filed a lawsuit against Starbucks in 2022, and that one is currently, there's a motion to dismiss pending. So we'll see how that court rules in that case.
Okay, so like when you go and you look at the menu and if it says allergens or if they have a note, will accommodate you, that's also a part of the suit, and then the idea that you're charging to accommodate somebody.
And the plaintiffs have actually made that argument that because Dunkin says, hey, let us know if you have an allergy, that they're sort of opening themselves up to making that reasonable modification. Moreover, they also offer the option to take out caffeine and sugar if you have diabetes or hypertension. So they're saying, look, you're accommodating this disability, but you're not accommodating those who are lactose intolerant.
What about the breadth of this? Because I think some of us have been around since the Americans with Disabilities Act came into law. I wonder if many people with more severe disabilities, if you will, I might be overstating that a bit, but people who need wheelchairs, people who are visually impaired, people who are deaf, do they think, all right, now you're going to water this whole thing down to the point where we may not get the service we need?
Right, that's a nuance, and I don't think so. I could see that argument, but here's why I don't think so, because of the way our common law system is shaped. So we have this statute that Congress passed in 1991 and then amended in 2008. And so that statute is broad. It says you have to make reasonable modifications, right? It can't cover every factual scenario. So then the way our common law, our judge-made law system happens is somebody comes in and says, hey, I'm lactose intolerant. And then they say, well, that is a disability. A court might say that, and therefore you have to make a reasonable modification. And that's how the law continues to evolve. So then the next person who says, I can't read, I'm blind or whatever, I can't see, then, do you have to make a reasonable modification on the menu to make it? And, that might be, there's lots of different ways to accommodate that. But the question is, will it essentially create an undue hardship? So here, Dunkin' Donuts, all they have to do is give the non-dairy milk for free. Right. There's no, and they might, maybe they'll point to the, they don't have to modify their building. They don't have to make changes, to a physical structure. So I think that's going to be a tough argument for them to say it's an undue hardship.
Okay. Well, this is just in the early stages. You're going to follow this.
Yes, we'll follow it. And we'll see what happens with the Starbucks one, because that will be ruled on before this one.
It's a lot of coffee law. Coffee. There used to be like...
Makes me crave some right now, though.
Contract lawyers, you had trial lawyers, now coffee lawyers. There's a big business.
It's a part of our life, coffee.
It is.
Thanks as always, Whitney.
Yep.